Yo.
Yes, sir. What's up, guys?
Yes. This DJ will kick the floor in 3, 2, 1.
Hello and welcome to Mzansi. We are back again. It's that time where we have to first deliver the story of the bail, of the case to be thrown out. This is Nandipha. And that's what we're going to deal with first before we give you other stories. There's more where we came from. But yeah, Emily, this is Mr. Anonymous for those who do not know me. And I urge you, before we start, to subscribe and like the video before you even start going further and getting drawn into this story itself. Please like and share and do everything that you need to do. And then let us start. This is Emily in front of you. For those who do not know her, this is her. Let us roll.
This is me. This is I. Well, I'm a bit relieved. Sesingathi kancane. Indaba kaNandipha.
Yeah.
Because bambe asiqinile ugirl singazi ukuthi is she not? Does she have a kid? Does she not? So for now we can breathe.
Yeah.
Okay? Magudumana lost the bid to declare her arrest and deportation from Tanzania unlawful. But yes, guys, welcome to Mzansi Reality. Here we go through the details. So we're going to go through the judgment of the judge as to what reasons he gave, what was happening. Loubser, Judge Philip Loubser. Is it Loubser? Loubser.
Yeah.
Yes, he gave a judgment today. So Magudumana lost her bid to declare her arrest and deportation from Tanzania unlawful. So Dr. Nandipha and Advocate Katz were not in court today. Well, Dr. Nandipha obviously hasn't been showing up ever since this trial of this particular case has begun, but it was surprising to not see that Advocate Katz was not there.
Okay.
So Judge Philip Loubser gave his judgment today, and it read as follows. So Judge Loubser went through the circumstances arising from Magudumana filing this urgent court application. He also went through what she is seeking, which is to set aside her arrest and legal proceedings against her. So the applicant is said to be a girlfriend of convicted Thabo Bester, and a number of suspects have also been arrested and are appearing in court on the jailbreak. It is the circumstances around her arrest and deportation to South Africa that prompted her to launch this application.
Yeah.
So Loubser addressed the issue of urgency. It appears from the papers before him, is what he said in the morning, I quote, before me, that she has been in South Africa since the 13th of April. From 14th of April, she was in consultations with her lawyers, which is some of the points that you guys brought up before. Is it urgent? Is the application urgent? But the judge confirmed today that, you know what, you have been in South Africa since the 13th of April, and on the 14th of April, you were already in consultations. So applications was only filed on the 19th of May. That's more than a month later. So Magudumana has not met criteria for launching application on an urgent basis. She also doesn't give reasons why she waited for some time to launch it. Magudumana gave respondents 3 days to file their papers. Despite shortcomings of her application on urgency, he said, I am enrolling the matter in the interest of justice. So that was the first part on the matter of urgency.
There was indeed. Do I give the judge a good 10 here? Because indeed, the issues of emergency, they must show that urgent when you are doing them. So in this case, obviously, this person came in South Africa and took time to consult with the lawyer, and then they decided then to do all these things in a hush-hush way, to hurry and run with the case in this manner.
When they've had more
To
than a
strike
month
that
to
down,
prepare.
To strike that down, it shows indeed that there was too much consideration on this, and the judge deliberated on it and then came into a conclusion. I cannot fault the judge here.
Okay, so as for urgency, that in the normal course of business, certain timeframes are applicable. The court must be satisfied that the requirements for urgency are met, and this application was only launched by the applicant on the 19th of May 2023. She has not complied with the requirements for urgency. I am of the view we are not dealing with a normal application of urgency despite the shortcomings of the applicant. I will hear the application on an urgent basis. Now, Loubser then went through what was filed by the respondents, namely SAPS, NPA, and Home Affairs.
Yes.
The state denies Makudumana was abducted, insists deportation processes were above board, and Loubser went through her affidavit on what she says happened during her arrest.
Yes.
Loubser also went through what the respondent said regarding the handling of the deportation process.
Yes.
There is factual dispute as to the arrest of the applicant and the circumstances in which she was transported back to the country. Okay. Loubser said Makudumana insists she was forcefully put on the plane. She refers the court to statements made in the media by government officials who said they were sending a delegation to Tanzania. Makudumana rejects that she said she wanted to return to South Africa to her children. Okay. Now, this is where I felt a little bit sad for her children, because she is putting it as a matter of fact in public that, you know what, she never said that she wanted to come back to her children. You know, was it intentional for her to drop them off at school and never fetch them and run away with an ex-con, not even an ex-con, a convict? Does it sound like she had no choice but to do what she had to do? Because to the kids, I'm very worried that this is sounding like she was not coerced and a willing participant more than anything. You'd think she'd want to hide that from her children, because this is public now.
Look, would you jeopardize your case in this instance, where you know that your only chance of fighting is to go the other way around, not trying to look at your kids at this point in time as you're fighting for your life? Because if he says that, or if she was to admit to that, then it weakens the case. If she says, yes, I said that, so that
she's
that
planning
gives
on
them
explaining later to her children that actually I just wanted to get the case over and done with.
Yeah,
that makes it look even worse.
That gives the states more ammunition. In fact, you wouldn't even have a chance of applying to the next court or magistrate, basically. So I didn't expect that to come out. You are thinking as a person who would think for your kids,
as a mother,
but you are not in her shoes. What would you do to get into your kids if you were to get a chance where you had to fight for your life to get into your kid? Wouldn't you use everything that you have?
But obviously this was never gonna go the way that she was hoping.
Maybe that's what you are thinking. If that is what they are feeling, why do you think they are going further with it?
Well, Makudumana claimed in her court papers that she was blindfolded and abducted and had been subject to a disguised extradition when she, along with convicted Thabo Bester, were handed over by Tanzanian officials to South African officials. Yes. They were then flown in a private plane flanked by SANDF and SAPS back to South Africa on the 12th of April. Now, Judge Loubser said he accepted the version presented by the respondents, the National Director of Public Prosecutions, the Minister of Police, and the Minister of Home Affairs, that she had told all and sundry that she wanted to go home. Makudumana, in her replying affidavit, bluntly disputed this. However, the judge said, in terms of established law in South Africa, over 6 decades, where there is a material dispute of fact and the matter is not referred to oral evidence, it has to be adjudicated on facts stated by the respondents, unless that version is palpably implausible and far-fetched. So it means Makudumana herself, in her story, she did not have anything to back up what she was claiming had happened.
So the onus was on Makudumana to prove that that was the case. And so far, there is no proof.
So the
Do you think there's a proof though?
if it was there, she would have taken it out. Now she must go and look for it to prove her case for the next phase. By the way, guys, she's not done, okay? She's taking this to the constitutional courts.
Yeah.
She's not done. So the answering affidavit on behalf of the public prosecutions and SAPS states that when she was handed over by the South African High Commissioner in Tanzania, she did not verbally or otherwise offer any resistance, the judge said. He said he had no doubt that at the time Makudumana was well aware of the charges that would be leveled against her, but had nevertheless consented to her removal. So, is there proof that Makudumana provided that she resisted her arrest?
Provided that she is the one who's submitting all these allegations. But who alleges must what?
Must provide receipts.
Must provide receipts or something like that.
Must prove their case.
In this case, the
He
owner
who
still
alleges
remains.
must prove their case.
Yes, must prove their case. So she did not do that, as you mentioned the last time we reviewed, that you felt that there was a lack of evidence.
Lack of evidence. Word of mouth is not enough in this instance. Girl, you have lied way too much. Hallelujah. At this,
did you lie?
At this point, no.
I can't say she lied. Let us say the judge.
No, I'm saying in previous incidences she had. Have you forgotten the Mushendiki incident?
Oh, the
Have
Mushendiki.
you forgotten how she vehemently denied that this is what was happening at the time?
Yeah.
So she has not proven herself to be.
She
honest.
has not bathed herself with glory.
No.
Okay, no, we understand
So
that
I
part.
cannot.
And I agree with you in this case, because we all would like to see the law prevails in the right way.
But word of mouth is not sufficient.
Word of mouth was never
in
sufficient.
this case of Makudumana.
But they would not go further unless they have something on their sleeve. That's my thinking. I mean, considering the experience of a man.
She got the money. She can do whatever she likes with it, allegedly, if it's there. Free State High Court Judge Philip Loubser, in his ruling on Monday, found that she had consented to her removal by South African Home Affairs officials from Tanzania because she wanted to return home to be with her children. At the very least, she had willingly acquiesced to her transportation back to South Africa, the judge said.
So what we are relying on here, in case you don't understand also, because the question might be, why do we need to trust the state more than the person? I think you submitted that part to say that if there's no evidence, then the respondent's response is the one that is taken upon. Is that the case?
Not necessarily, but in this case, the judge did what he had to do.
Yeah, I'm trying to
The
say.
state and Home Affairs provided a bit more weight. There were statements, there were affidavits signed by Tanzanian officials declaring,
Yeah,
there was weight.
Due to the weight provided by Tanzanian authorities, therefore the state is reaching that conclusion. The judge is reaching that conclusion to say that I'm finding two authorities who are of different sovereignty. Mm-hmm. So I will take them as the truth.
I mean, even went as far as to say that she should take it up with Tanzanian authorities. I don't know how many of you guys caught that.
Yeah, it did say that.
go take it up with the Tanzanian authorities.
Some of the things, there was that feeling of yourself uneasy to say, why are we discussing it here? But then there was that part of argument of saying that they were not given time there. Apparently, she was busy preparing, and then all of a sudden, they bamboozled and said, "Let's go."
I think the Tanzanian authorities had given her 3 days. Time was up.
Was the time up?
South African Ganapi manje.
When did that 3 days commence?
It commenced while they were caught. I think they were caught on a Friday.
Yeah.
That 3 days started commencing somewhere between Monday and Tuesday.
When was he brought back? When was she brought
Friday morning. Before they
So
had
it
to
was-
leave. They had to leave before Friday in Tanzania because they came here midnight.
So the 3 days had lapsed at the time.
They had labs.
3 working days.
They had to get out of the Tanzania.
And then there's no case. She's got no case. She's got no
So
case.
the judge said, however,
Whatever you do, you need to do it within 3 days.
yes,
And she's saying she was busy trying.
she was busy still
No,
talking.
she's grasping the straws. She's got no case. There is really no case if that is the case. 3 days had lapsed. And that's where they are going to even if you bring them here, that's what they are going to say.
And if Tanzanian authorities are the ones who took her to the airport is the next port of destination out of the country.
Exactly.
So you decide for yourself what that looks like. So the judge said, however, that he did not agree that the team of South African officials who flew to Tanzania to get Makudumana and Bester had done nothing wrong. It is patently clear on their own version that they willingly participated in the handing over event at the airport, believing it was done in terms of international law and law in Tanzania.
Yes.
The respondents were aware that she was handed over for purposes of her persecution. What they did not realize was that it was an extradition without process and not a deportation. This is what the law says, he said. In his ruling, he explained the difference between deportation and extradition. Deportation is the removal of an illegal foreigner. Extradition is the handing over by one state to another of a person accused of a crime.
Yes.
Loubser said the reference to a disguised extradition was the use of refined terminology which she had stated in her founding affidavits.
Okay.
And this juncture, the replying affidavit of the applicant, she contends deportation disguised as an extradition, it is not a lawful mechanism. So the applicant also maintains the plane arrived within minutes of the issuing of the notice of deportation. She says there was a collusion between the two countries. She bluntly denies that she had not objected when handed over to officials of Home Affairs. Reference to a disguised extradition was the use of refined terminology, which she stated in her founding affidavit. Loubser said Makudumana never mentioned she had instructed a lawyer in Tanzania in her founding affidavit and only mentioned it in her replying affidavit. Therefore, he struck that out as well. Take it up with the Tanzanian authorities.
Nicely dealing with the evidence in chief. So I think in this case, the case is closed for now.
For now, I can breathe. Let's focus on the trial. But I don't know if she's going to allow it to happen since she's insisting on taking the case to the Constitutional Court. Well, her lawyer, after instructions, went to see Makudumana.
Okay.
And after instructions, he's saying that based on the fact that even the judge said this is an extradition and was not a deportation, they are going forward to the Constitutional Court. They're taking this up there.
I feel like the judge, as much as he has opened that door.
But he did what was right, in my opinion.
But again, you see what my worry is that the
So you
issue
wanted
of,
him to let her go?
No, the issue of extradition the fact that you have put a rubber stamp on it to say this is the
It was
case.
an extradition and not a deportation.
They are now.
But that it would be unethical of him to call it a deportation when he knows, from what he knows in his opinion or what he has learned, to call it something else when it's not. If it's an extradition, it's fine. It's an extradition. He made his ruling.
But then, if it's an extradition, then that means the guy won in a sense.
In a sense, but did she win entirely? They gave it to her. They're like, okay, you can have that, it's an extradition, but that does not mean that you're gonna walk out of here. It was an extradition. It was not done properly. You can take it up with the Tanzanian courts. That was not the responsibility of Home Affairs alone. Home Affairs was acting on the instruction of Tanzanian authorities. So she can take it up with Tanzania.
Yeah, the issue is gonna be Tanzania here, but this guy, I think his experience, as you're saying, he was reading a lot. His experience, though, has created something out of nothing.
You wanted him to say it was a deportation.
It would have collapsed the whole thing.
It's not his work. It's Home Affairs and NPA and SAPS who mentioned the handing over. And you are the one who convinced me that there's an argument in that whole handing
there is
over.
an argument. I'm not saying that it was wrong for him, but I'm saying that because of that deportation, that extradition thing being accepted, maybe there's more to come. That's why I'm saying
I let it come. Asenantaba ukamanje ukuthi the ruling has been made. That is all I care about. She can keep fighting. It's her money. Like I said before, it's her ka-ching-ching. She can do whatever she wants with it. If she wants to take it to constitutional court, then she can go. Ntagabao, who are we to stop her? It's her right. But for now,
the thing is that is postponing the case, though the original case. That's my
no. Bester and the 5 accused can continue without her. Then utlatla inatloseka afterwards. So what do you say?
There's not gonna be such thing as that.
Then they will sit in the jail and wait for her to finish with.
Yes, they must wait
court.
for her, and then there's still gonna be Baxter
while
coming.
They are sitting in the prison.
Baxter might also be part of the people who are going to say, "I need bail."
Well, as long as I do in the prison, I don't have a problem with that. But at the end of the day, you can't run away forever from this trial. It's coming and it's gonna happen. Awubuze #justice for Senzo
It's gonna happen at what cost? That's what I'm trying to ask. Maybe that brings us to the next.
You see, what got us in this mess in the first place was rushing. You understand what I'm saying?
I do understand it, but I'm saying
it is the rushing. So we cannot rush.
Here is the next story that we are going to deliver. That says crucial people are deciding to eliminate themselves. But it's the next story, guys. Please bear with us. We'll cover it.
We just wanted to cover.
Those are crucial. Those are crucial people that we are talking about now. I'm saying, is this case then not gonna become what we have been dealing with, like Senzo Mewa's case?
It's going to be, and I'm going to say that as a country, we need to prepare ourselves for that. It's gonna be like the Senzo Mewa trial. It's gonna drag. Nandipha is making sure of that. There's still Bester, by the way, who's denying himself. Remember that.
It's alleged.
Allegedly.
Well, everything we say here is alleged, as we all use the same information that everybody uses.
He said her reference to consulting a lawyer in Tanzania is struck out. Loubser said that the statement made by government officials that Magudumana refers to in her replying affidavit. These statements were made in April. He says that she didn't add these statements in her founding papers and struck it out. Loubser went through the case law in terms of deportation and extradition. He referred to a case law determined by Supreme Court of Appeal, which held the transportation of a person investigated for criminal offenses from a foreign jurisdiction is consent to. There is no violation of such a person's fundamental human rights or international law. Now, Loubser said deportation is usually a unilateral act while extradition is consensual. Did you hear that? It's a unilateral act, that's deportation, while extradition is consensual.
Okay.
There has to be an agreement. So him ruling that it was a deportation was not gonna, while the affidavits of the Home Affairs are saying otherwise. Is there evidence then that South African officials colluded with Tanzanian officials? Loubser then mentioned the SADC protocol to combat illegal migration and whether Makudumana was deported or extradited in terms of the agreement. So Loubser mentioned the notice that was given by South Africa by Tanzania declaring Makudumana and Bester undesirable immigrants, and that respondents deny that South African police arrested the pair in Tanzania. So Loubser then mentioned the affidavit from an official at the High Commission that is contradictory. He said, it can't be that on the one hand Tanzania decided to deport and then on the other hand an agreement was reached to deport. You see now, Loubser said it is patently clear that the respondents willingly participated in the handing over at the airport, believing that such handing over was done under international law. They didn't realize this handover was an extradition and not a deportation. So Loubser, in the present case, he said, I have no hesitation that Makudumana was aware of the charges that would be leveled against her in South Africa. She consented to her removal. He said, I find the application cannot succeed. It is dismissed with costs. He said, I'm bound by this, dismissing Makudumana's urgent application for an order declaring her apprehension in Tanzania unlawful, as well as her arraignment before the Bloemfontein Magistrates Court and warrants for her arrest null and void. He ordered her to pay the costs. Remember while we were doing a video, guys, and telling you that if she loses this case, she's gonna have to pay. And Loubser referred to government statements made in April, which Makudumana also mentioned the fact that she didn't add them in her founding affidavit means that that was also struck out too. And the key question is whether there is evidence that South Africa and Tanzania colluded to have her surrendered to the country. There is a SADC protocol which guides this. So the court has to accept that the decision was taken by Tanzanian authorities to deport her to the country of origin. It is clear that the respondents willingly participated in handing over events at the airport in Tanzania, believing it was done so in terms of international law. They didn't realize it was an extradition and not a deportation. The applicant was aware at the time of her handing over of charges she would face. She nevertheless consented. Based on that, the application is dismissed. So Loubser in the present case said, I have no hesitation that Makudumana was aware of the charges that would be leveled against her in South Africa. Angitiabo. She consented to her removal. I find the application cannot succeed. It is dismissed with costs. That was good news for some of us. That was good news that it was dismissed with costs. That means she has to pay the legal representation for Home Affairs, for SAPS, as well as the NPA. That was nice. But then Sizotini, Nandipha Makudumana has lost her bid for freedom, okay? She will have to now take it up with Constitutional Court, and her challenge to her arrest, detention, and trial is dismissed with costs. Dr. Nandipha Makudumana's application was dismissed, meaning that she'll have to pay the police, NPA, Department of Home Affairs legal bills. Now, that's a lot of money. And according to a source within the legal fraternity, Magudumana could be slapped with a bill of anything between 200,000 rands and 300,000 rands.
Right.
Maybe it's a change compared to that 817 million we heard about, allegedly. Perhaps this is change. But then legal analyst Melusi Kulu told EWN that he believes that Magudumana has two options, okay? One of the options is that she might appeal the decision, but she might also go on and apply for bail. Kulu said that Magudumana's bail application would provide details into the role she played in Bester's escape. So when she applies for bail, he said that we are expecting the state to bring evidence of how she is linked to the case, to that case, the specific case, the trial of what was happening with the escape.
Okay. Oh, well.
That's a wrap. Well, that's it for me, guys. Tell me what you think in the comment section down below. Are you happy as I am about this decision? Okay, I do not want to look at the constitutional. Once you go constitutional, it's going to take forever. Ne? But as long as they're in jail, now I'm fine.
All right. I think let's cut it here. For me, nothing much to say. Let us wait and see what happens next.